Halyna Gutierrez was recently convicted in New Mexico of involuntary manslaughter for the shooting death of cinematographer Halyna Hutchins on the movie set of Rust. She was the armorer. She was in charge of the weapons. Alec Baldwin had the weapon. His trial is set to go forward in July 2024. So today we are covering the defense's motion for new trial. The defense's motion for new trial essentially said, Your Honor, there's a new case. And obviously, Halyna Gutierrez gets a new trial because of this new case. Trust me, bro, it's fine. Court today is being held via Zoom or WebEx or Google Meet or whatever. So it is court over video today. And this is all leading up to Hannah's sentencing that is currently set for April 15th, 2024. Emergency motion for new trial and release. So he's arguing two things. He wants a new trial for Hannah because, trust me, bro, and he wants her released from custody. The New Mexico Supreme Court just issued its ruling in State of New Mexico versus Taylor, the heart of the defense's argument. Any jury instruction using and or means new trial. I don't think that's what the court ruled at all. I think it's much more nuanced than that. We're going to get into the state's response. This is precisely the argument Ms. Gutierrez made in the jury instruction arguments. Remember, if you do not make an objection at trial, you lose the ability to appeal and make further motions on it. You have to preserve the objections. This is one of the difficult things about being an attorney, is that when you are in trial, you are thinking of all the possibilities and trying to think down the road for everything that could be a problem. Even if you're going to not object, and argue for a million years on it, you have to say, Your Honor, we object to that jury instruction on these grounds. It says these arguments were overruled and the state made the same error using the and or instruction. Where is the rest of the argument here? Because there isn't any. No argument on the law, no argument on the facts, no breaking down of the case. This jury instruction is virtually certain to result in the reversal of a trial conviction under the new Taylor opinion. False. False. It would be a manifest injustice to keep her incarcerated while further proceedings related to this important issue occur. Sir, okay. Okay, sir.
I have read Taylor. I've read
too.
Gaudet. I've read Consul. I've read very many cases. I'm very aware of what occurred at trial. I'm very aware of the discussions that occurred on regarding the jury instructions. And I am denying your motion, Mr. Bowles, because I do not think that Taylor requires a new trial. In this case, I think that
This is specifically going to the fact that she's not kicking the can down the road and making a ruling. Thanks, Your Honor. She's just like, no, I am well aware. We're done. I'm going to let her make the rest of her record on why she's denying this motion for new trial.
I do not think that Taylor requires a new trial.
I agree.
In this case, I think that the issues in this case, the jury instruction in this case, are distinguishable
I
from
agree.
What happened in Taylor. I'm not going to. I'm going to provide a written order outlining my reasons so that there's no misstatements of what I'm to make an oral determination. So I'm going to do a written order, but I wanted to let you know that I'm denying your motion for a new trial. I will put it in an order. You should get that on Monday. And we are staying the course on the sentencing.
Okay. Period.
Yes, Your Honor, and I had one additional request to the court in my motion, which was, and if the court were to address this at sentencing or to address it now, which was to consider release of Ms. Gutierrez-Reed pending an appeal.
I don't think
and
you
a
want
writ
that.
we would take
I don't
for
think you want
guidance
that.
from the appeals court and Supreme Court. And I just wanted to.
I don't think you want that. I don't think she's going to get released, but I don't think you want that because I think there's a very real possibility that Hannah could get sentenced to a sentence that will be tantamount to time served. I don't think you want her to come out and then have to go back in at sentencing. Sentencing is what, April 15th? I don't think you want her to be released until sentencing and get out and have to go back in and process all the way back in. I do think there is a very real possibility that whatever her sentence is, custody-wise, I think it'll be a longer probationary sentence, but custody-wise, I think the amount of time she has served might mean that when she is sentenced, she will not be held very much longer. I don't think she needs to be out pending appeal, because I really think she's going to get mostly a time served sentence, or a sentence. If she gets 6 months, she might be in another few weeks. I don't think you want that. I think it's more of a pain in the ass for your client.
Add to that, she didn't have any violations pending trial. She takes care of her father, who has been diagnosed with leukemia.
Well, that's
She
unfortunate.
works, and she has been in counseling. So she hasn't done anything wrong. She's not a danger.
I- I think he's referring to because she was out of custody this entire time from the incident to the trial. I think that he's saying she hasn't done anything wrong in her pre-trial release, but she has been convicted. But I do think he is referring to during her release before trial, she didn't violate the terms of her release. I think that's what he means. It just post conviction sounds really weird to say it that way, but I think he's referring to she never violated her terms.
Didn't have any violations.
I think that's what he
pending
means. I
trial.
backed it up a
She
little.
takes care of her father, who has been diagnosed with leukemia. She works, and she has been in counseling. So she hasn't done anything wrong. She's not a danger or a flight risk. And I think there's an appellate issue that we have stated that we will raise, and a potential Supreme Court writ. And I just think it's unfair if there's any chance of the Court of Appeals or Supreme Court seeing it differently, that she served her whole sentence on the chance that it could be reversed. So I'm just asking the court to consider that based on all.
Well, you don't know what her sentence is yet, though. Like, you don't know what her sentence is yet. So there's no argument that she's going to serve her whole sentence while waiting for appeal, because you don't know what her sentence is. You're going to have to wait like 2 weeks.
Those grounds and the fact that she hasn't had any violations.
Bring this argument
Ms.
later.
Marcy.
Well, we do oppose Ms. Gutierrez's release. If this were like a motion to review conditions of release, I certainly would have been able to address my concerns with regard to Ms. Gutierrez
But
and
that wasn't
potential
made.
release. I'm opposed to it. Does the court want me to go into I mean, I actually asked Mr. Bowles for proof of Ms. Gutierrez's employment history during the time that the case was pending, and any counseling and treatment that she has completed or participated in. To date, I don't believe he's provided me anything. So
Wow.
while Mr. Bowles wants to make these statements to the court this morning, these are things that I requested from Mr. Bowles, I think, over a week ago. I did it almost immediately after the trial so that I could be thoughtful
In your sentencing
in
memo?
terms of coming up with a sentencing recommendation at the sentencing
That's
on
appropriate.
April 15th, and I've received absolutely nothing. In terms of
That's, I
Ms.
mean,
Gutierrez's full compliance with her conditions of release, I think there are some arguments to be made there if the court wants me to make them now.
The jury found Ms. Gutierrez Reed guilty. She is.
excuse me, Mr. Bowles, when you said she didn't do anything wrong, the court would like to redirect that sentiment and remind you that she has been convicted. I truly do think what he meant was in pre-trial release, that she had no violations, she had no issues, but that's not how it came across to the court based on this court's response.
The jury found Ms. Gutierrez Reed guilty. She is incarcerated at this point. She's facing incarceration time. Keep in mind, there was a death that the jury determined was caused by her. So I am not releasing her. All right. Thank you. We are in recess.
Hannah Gutierrez was in court via Google Meets today with her attorneys and the prosecutor and the court. The defense, of course, arguing for a new trial and for release. The court denied both of those requests and denied the request for further briefing, denied the motion for new trial, and agreed with the interpretation of the case that was underlying this very threadbare defense motion that the prosecution took. And I interpreted it that way as well, as did everybody but the defense. Will the defense appeal this post-sentence? Probably. Will we see what Halyna Gutierrez's sentence will be shortly? Yes. Her sentencing date is still set for April 15th. That will be an in-person in-court hearing. I anticipate that that will be streamed and we will see her sentence that day. She is facing a maximum of 18 months in prison. This is also a case where there is no floor to her sentence. So there's no mandatory minimum prison sentence. So could she get probation and time served for the time she's been in custody since trial? Yes. Could she get a amount of time anywhere between 1 month and 18? Yes. Could she just get probation? Yes. I mean, they would give her time served as well, but yes. So this is a case where it is not a foregone conclusion that she will spend a substantial amount of time in custody. It is up to the judge. And we heard a little bit at the end of the hearing that the prosecution has asked the defense for certain information to inform their sentencing recommendation. But we will see all of that at sentencing. And the judge reminded the defense at the end of the hearing that this is a case involving a death, that Halyna Gutierrez is facing prison time, and that she was convicted by a jury. We will see what happens in this case at sentencing, and I will see you soon. Bye, guys. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.